Hi, I'm Ruth George, and this is the Good Life and Legacy podcast, where we explore answers to the question, how are you creating a great legacy by living well, planning well, and supporting those that you care about? And today I am joined by Paul Hood. Paul Hood Jr. is a frequent speaker and commentator on estate, charitable, and tax planning issues. His articles have been published in many journals, including CCH Journal of Practical Estate Planning, Trust and Estates, Probate Practice Reporter, Estate Planning, Digest of Federal Tax Articles, Louisiana Bar Journal, and Tax Ideas. In addition to serving on the Louisiana Board of Tax Appeals, he was a sponsored speaker for distinguished law schools such as Duke, Georgetown, Notre Dame, NYU, LSU, Tulane, and Loyola New Orleans. He is also the author of 9 books on estate planning, charitable planning, and business valuation. Along the way, Paul has been a father, godfather, husband, lawyer, trustee, director, president, partner, trust protector, director of planned giving, expert witness, agent, professor, judge, juror, respondent, and defendant. He uses his expertise and experience in these myriad roles to guide others. Paul is an author, speaker, and consultant on tax, estate, and charitable planning. He is also a purposeful planning educator at Paul Hood Services and an ambassador at Purposeful Planning Institute. Welcome, Paul.
Thanks, Ruth. Really appreciate you having me today. Glad to be here.
So happy to have you here. So we are talking about buy-sell agreements today, and you wrote a book called Buy-Sell Agreements, The Last Will and Testament for a Business. But I'm curious why you wrote this book. You indicate in the book that it was personal. So what's the backstory about that?
Well, when I was a kid, when I was 8 years old, growing up in central Louisiana, the town of Alexandria, right at the dividing line between Roman Catholic South Louisiana and Protestant North Louisiana. The central part of the state is the city of Alexandria. But I have, at least on my maternal side, pretty strong Cajun roots. My great-grandmother, who I knew, she didn't speak English. She only spoke Cajun French. But so one day, during the summer when we were kids, we ate our big meal at noon. In fact, when my dad was a CPA, he'd come home from downtown. He was in public practice. And we would have lunch at 12:15, not 12:10, not 12:20. Lunch was on the table at 12:15. During the summer, when we were out of school, my grandparents, who were Momo and Papa, would come to our house one day a week. And one day a week, we'd go to Momo and Papa's house, where we were joined by my mother's brother, Bobby, who worked for my grandfather at Alexandria Seed, which was our family business, and my aunt and my cousins. So one day, it was, because Bobby and they had 3 kids, we had 3 kids. They put the kids at a different table than the adults. But one day, it was some serious talking going on. All I remember hearing was Uncle Bobby got fired and Papa was getting redeemed. Now, when I'm 8, we're like, oh, what the hell that means? Well, the next morning, we listened to the same radio show every morning. It was on KLB 580 AM on your dial, and it was the Bruce Rainey, Bill Day show, otherwise known as the Rainy Day Show. And those guys were on the morning show at KLB for about 40 years. But they start at 5 a.m. and, they used to do the Evangeline Parish Farm Report in Cajun French. But that day, they're talking about my family's fight.
Really?
Oh, yeah. Oh, yeah. Oh, absolutely. So
Wow.
I really, Bobby started another business, and my grandfather took the money that he got in the redemption and bought a bunch of rental property, and that was really what he did for the rest of his life. Well, when I'm in law school, my grandfather dies when I'm a junior in law school in 1985. And I go on and I finish. I go to Georgetown and I go to New Orleans in 1988 as a newly minted tax lawyer out of the get my LLM in tax at Georgetown. And I'm practicing law with a downtown New Orleans law firm. And one day I'm sent to Baton Rouge with corporate documents to file at the Louisiana Secretary of State's office, and to check a few things and to pick up some stuff that we were waiting for from them. Well, I had to wait. And while I was waiting, my curiosity got me, and I said, bring me the charter of Alexandria's Seed. And so, a few minutes later, I come back, and it had been recently dissolved. But, the old book, with all the articles in it. And I thumbed through, and it was, I think the corporation was formed in 1923. And my grandfather had a partner who was 10 years older than him. And they were really equal partners, and they ran the business. In fact, my grandfather was really the spearhead behind the business, and he made most of the day-to-day big decisions. Because Papa was a deferential guy, and his partner was 10 years older, he gave him the 51% and 49%. And in the articles, now usually buy-sell language is not in the public document, okay?
Right.
It's usually in, an operating agreement, if it's an LLC, or a partnership agreement. Of course, limited partnership agreements often have to be filed with public record in some states. But in this case, it was 1923, Central Louisiana. The buy-sell language is in the articles. And what it essentially was a perpetual call by the majority stockholder at book value. Now, the business was founded, like I said, I believe around 1923. This was 1968. They've been in business for 45 years and got over 100 employees. So that business was worth a heck of a lot more than book value. So, I was like, gosh, I see this. Of course, karma came back and bit the other family, because the son who spearheaded what happened was my uncle came into the business, my grandfather's partner came into the business, and the two boys were like all in water, and it was a continuous tete-a-tete, as we would say in Cajun land, and eventually the son, harped on his dad and then got him to approve, firing my uncle. So I get to this firm, and like my third day, two litigators show up in my doorway. And they're like, "You got a minute?" I'm like, "Well, yeah. I just started. They hadn't loaded me down with work yet." And like, "We got a buy-sell agreement." These lawyers did malpractice defense work, and it involved an alleged mistake in a buy-sell agreement. And it was further complicated by the fact that our client is now a former practicing lawyer, because he is a Senate-confirmed federal district judge. Okay? We want you to read this buy-sell agreement, particularly this particular provision, and we want you to tell us honestly what you think about it, because we don't really understand it, and we're litigated, So I look at it, and I was like, why did he use that term? And they're like, aha, that's the $64,000 question. We're trying to figure out how to advise our client, the carrier, whether they just need to open their checkbook and just get this over with. Because you see, in buy-sell mistakes, I call it the circle of life. happens is lawyer drafts a buy-sell agreement. There are defects in it. Nobody thinks about it, knows about it until a triggering event occurs.
Yeah.
The triggering event under the agreement occurs, and then all of a sudden people realize something's wrong. And of course, the people who benefit from the mistake or the error, they want to hold to the agreement. And of course, the people who are getting skewered by it, they're like, no, that's not what it meant. And of course, eventually, they litigate, and there's a loser. And the loser ends up suing the lawyer for malpractice. Like I said, sort of completes the circle. So we're now in the lawyer being sued for malpractice. So it's like, we're going to eventually have to take this judge's deposition, but we don't want to talk to him just yet. Can you talk to him? So I was like, okay. So I invite the judge to New Orleans. He was a down the bayou, as we would say, judge, from outside of Orleans Parish. And I invited him to I was a member of a lunch club. I said, come have lunch. And I actually, as luck would have it, I went to law school with his son. Oh. So I knew his son. Okay. So we have lunch, and we get, I like, Judge, I read that by, he goes, oh yeah, that damn thing. And I'm like, but there's a term in it, Judge. And I don't quite, educate me on what you meant by that. And he kind of looked at me and he said, sometimes you got to create additional work by building in an ambiguity to give people to argue about later on down the road. Aye. And I was like, we will never let you say that in a deposition. But of course, as a federal judge, he's confirmed for life, unless he's impeached, and it's very difficult. There's only been 15 federal judges impeached in the history of the United States, and since 1900, I think only one, Alcee Hastings, has been impeached. So very difficult. But the bottom line is, I started right then and there writing about and presenting about buy-sell agreements. Mm-hmm. And one of my law firm colleagues and I wrote a pamphlet on buy-sell agreements for Prentice Hall in '89, the year after I got to the firm. And I just kept, and then all of a sudden I developed an expertise in it, and I started getting referrals of cases in. And so that's really, but it was all motivated by, the family experience. So that's why I called it personal.
What a story. From 8 years old to law school and doing that due diligence as far as finding out what happened and then continuing on. And it brings up so many points about what we're talking about with buy-sell agreements and protecting not just the business, but the individuals. And especially if you're a minority shareholder or business owner or member owner. So very interesting. All right, so let's get into some buy-sell agreement information. So although there are 3 types of buy-sell agreements, you only use one of them. Can you explain why?
Yes. In short, the 3 types of buy-sell agreements, and actually by using the one I use the other 2. Yeah. Okay. There's what's known as a redemption agreement, where the entity is the buyer of the interest. There's the cross purchase, where the other owners are people who don't own yet, but who are parties to the agreement and have obligated themselves to buy the interest of an owner on the occurrence of a triggering event. They're the buyers. The third type is what's called the hybrid. And the hybrid uses the redemption model and the cross purchase model, because depending on the triggering event you choose, sometimes it's better for the entity to be the buyer, and sometimes it's better for the other owners to be the buyers. And I find that if you stick with a strict redemption model, for example, and there are a lot of insurance companies who put out specimen buy-sell agreement models, and they're selling insurance, and it's a simple the corporation or LLC owns the policy, is the beneficiary of the policy, and on the death of the owner, the entity receives the money, and in the redemption, buys the interest of the deceased owner from the deceased owner's estate. Okay, that's a simple transaction, but that's not that doesn't fully cover all the triggering events that you need that you should consider. So that's why I would never use just one. And then there are some cases where you wouldn't want the other owners to be the buyers. So that's why I like the hybrid, and I believe the hybrid is really the only kind anybody should ever use, because you can pick and choose which one is best for that triggering event.
Right. The one word is flexibility. We
Bingo.
need to build in flexibility because things change. People's
Yes.
lives change, tax laws change, the world changes, your life changes. So that flexibility is so key. And we never know the future, right? So building in that type of arrangement is so important.
Yep.
All right, so you distinguish between triggering events and responses to triggering events. So why is that distinction so important?
Well, one thing I've noticed over, because Ruth, if I've read or drafted or edited or given input on one buy-sell agreement, I've easily topped 500, and I wouldn't be surprised if I don't know the number over 30 plus years, but it might exceed 1,000. Okay. I've had as many as 20 buy-sell engagements on my desk at one time.
Wow.
Okay. So, in all kinds of situations, from drafting to litigation to being an expert witness, you name it. They happen along that circle of life that I talked about earlier.
Right.
The triggering event is the event that causes action. Okay, a death, disability, divorce, bankruptcy, competing with the company, loss of professional license, and there are a whole bunch of potential triggering events. Now, but what's important is not just the triggering event, but what's the appropriate response to that triggering event? Because the responses are on a continuum, and they range from no action to mandatory buy and sell, and all points in between. It might be a put, might be a call, might be cross-existent options, where I have the right to force you to buy me, and if I don't do that, then you have the right, to force me to sell. Okay, so either way, you have those things, and I know we're going to talk about the buy-sell options grid, and those two things, the trigger event and the responses, are the two axes of the buy-sell options grid. And I have to tell you, that one page, I'm a slave to one page things. I love, because I believe that if you can reduce something to a page, you understand it. It's easy to write, a book about something, but until you can boil it down to its essence,
Right.
I'm not sure you understand it, well enough. So this grid has been the most useful client assistance tool, and I used it to draft. And what you do is on the vertical axis are the list of triggering events, and on my website you can get the buy-sell options grid. It's for free. You just download it. And I have like probably 20 different, maybe even 25. I haven't counted in a long time, because the tool is more than 25 years old. and I tweak it periodically, but not much in the last 5 or 10 years, are the triggering events. Now, do you need to put all 25 triggering events in your buy-sell agreement? No. And most buy-sell agreements don't have more than maybe 4 or 5 at tops. And some only have 2 or 3. Okay, death, disability, divorce, maybe bankruptcy, seizure, that kind of thing. And then on the horizontal axis are the responses. And if you look at the buy-sell options grid, it's set up on that continuum from mere notice to no action to mandatory buy and sell, and then all points in between. And then probably 10 or 15 potential responses. So what you do is you sit down with a client and say, okay, and you got the business owners with you. You got this one page and they can see. You say, okay, on death, what y'all want to have happen? Do you want your estate bought out? Or do you want to give your interest to your heirs, if they're going to be in the business? What you want to have happen? And we can check the box. And they're like, yeah, death, we want mandatory, we're not related, mandatory buy and sell. Okay. Now, what about disability? Well, on disability, we got this, and you check a different box. And when you get through talking about the ones you got the guts of your agreement.
Right.
And let me tell you something. That experience for clients comes in really handy in 3 to 5 years when you force them to sit down to review the agreement. Right. Because I got news for you. Unless your clients are different than the hundreds that I represented over the years, they ain't going to read that agreement. When it's signed, they're going to shove it in their drawer with the Tic Tacs and the extra ketchups from the takeout restaurant and whatnot in a napkin, and they ain't going to read it until there's a triggering event. But when you sit down with them and say, okay, I want y'all all in, we're gonna meet and we're gonna review your buy-sell agreement. And of course they're like, humming. But when you pull out that sheet, like, it comes right back to them. Because they like, it's an instant recall. On death, that's what happened. And on disability, that's what happened. And that's why that tool is so helpful.
Right.
I've actually appended it to buy-sell agreements as an exhibit before. So it's a very, very useful tool, and I really commend it to people because it's an organized way to look at in a systematic fashion, what triggers it, and then what do we do about it? And that's really the two considerations.
Well, you can get lost in the maze of triggering events and options and how do we respond and who has a right and who has an obligation and how do we mesh it all together and thinking of all of the other items as far as what do we want the business to look like? What do we want for liquidity needs? What are tax consequences are we concerned about? And so you really can get lost in the maze of this and that. So that roadmap is exceptional. I love that. And I also like the idea in your book, the bad boy, you've got the involuntary transfers, involuntary transfers, and sometimes referred to as good boy or good girl or good boy.
Well, it's funny that you mentioned that. I am at my essence a pretty simple guy who was born outside the city limits. Okay. I'm a slave to common sense. And if you look at all the triggering events, some of them, the owner should be treated well. Right. And that's why I call them good boy or good girl or good person or whatever you want to do. But they wear the white hat. They're wearing the white hat.
Yeah.
Okay. And death, if you die, it's not your fault, usually. So you have that. And then you have the bad boy, bad girl, black hat, competing with the company.
Yeah.
Embezzlement, loss of professional license, being terminated from employment for cause.
Right.
The termination of employment for no cause is a white hat event. Okay. And that's why I kind of sort of put them in two camps, to keep things simple, for this simple country boy.
Yeah, I like that. I once reviewed an agreement, international, and it had good lever and bad lever. Actually, in the document.
Well, like I said, but what I'm telling you is certainly not rocket science.
Yeah.
It's really pretty basic common sense, and I think that's one of the problems that lawyers often get themselves into, because they overcomplicate things, and then you fall prey to the old Shakespearean "too cute by half." You're hoist by your own petard, and that's exactly what happens to you. You get yourself, you drafted your way into a cul-de-sac, and you can't get out.
Mm,
You know.
yeah. Well, you talk about the fire drill in your presentations, and this is a game that you play with business owners on airplanes about their buy-sell agreements. So can you explain what the fire drill is and why it's so effective at getting owners' attention about their buy-sell agreements?
I know when you're talking to me here, I appear to be a real gregarious and very outgoing guy, but nothing actually could be farther from the truth. I could walk into and always walk into a room of strangers, and unless somebody comes talks to me, I'm not going to talk to them. Okay. So I sit down on an airplane, and I usually have I'm listening to my iPod with music. But sometimes, there's somebody there that wants to chat. And and if they engage me, I mean, sure, I'm going to talk to them. I mean, I'm a pretty nice guy, and I do like to converse, but I don't like to impose myself on others, to start a conversation that they may not want to have. Okay. But when a conversation starts, and he's like, what do you do? Well, I have my own business. And okay, yeah, well, that's good. I said, do you have partners? Yeah. I said, do y'all have any type of agreement that stipulates what happens if one of you dies or leaves the company or anything? Goes, oh yeah, we have one of those. I said, do you know what it says? He goes, no, of course not. I signed it. My lawyer told me it was okay, so I signed it. It's in the drawer. I said, okay. I said, humor me. So remember when we were kids, we played make believe, a game of what if. And so we're going to play a game of make believe.
Yeah.
And I call this game the fire drill. What I want you to do is I want you to pull your buy-sell agreement out when you get home and play the fire drill. I want you to pretend that a triggering event under your agreement has just happened. And it could be your death, it could be your partner's death, a spouse's death, a divorce. It doesn't matter. Some triggering event. So now what I want you to do is I want you to get into the details. Find out, is there a transaction that's required? Is there a mandatory buy and sell? Or is there an obligation to sell or an obligation to buy? A unilateral obligation to buy or sell. Value. Who determines the value? How is the value determined? Okay. How is the consideration paid? Does it have to be paid in cash? Can it be paid in a note? If a note, does it bear interest? Does the note permit security? And I said, what you're going to find out, in my experience, having reviewed hundreds of buy-sell agreements, and this number is going to shock you, but this is the honest to God truth. I find that 90%, 90% of buy-sell agreements that I review drafted by other lawyers have significant defects in them. And these defects manifest themselves in one of two ways. First is some party is either going to have been royally screwed and really, really negatively impacted, or the agreement contains an ambiguity in the process of the transaction that that causes litigation or makes it, the malpractice carriers hate the words when I say, this is suggestive of litigation. It's time to open the checkbook. They know what that means. But I said, so there you go. I said, chances are 9 in 10 that your agreement has a significant defect in it. That you're either screwing somebody or they're screwing you, or you're going to have to fight, the ambiguities, and the lawyers are going to win.
Mm-hmm.
I said, so the good news is that this is a fire drill. This is make believe. But the bad news is the clock is ticking. And so when you get home, you better pull out that agreement, Shaq, because the clock is ticking. And if the triggering event occurs, it's too late. The ox is in the ditch, and the parties are now, steeled in their positions. The one who benefits from the poorly drafted agreement is going to want to hold you to it. And the one who's getting their ox gored by it is going to say, no, that's not what it meant. It couldn't be what it meant, Your Honor. And then you lose, or somebody loses, either side, and then they sue the malpractice. They sue the lawyer and the malpractice carrier for the lawyer. So that's the fire drill. And let me tell you something. It generates people I have people pulling pads out, make a note to self, pull buy sell agreement out. Which,
yeah, think about if your uncle had done that.
Because they get a phone call from their lawyers when they get home, and the lawyer gets business.
Yeah. What about if your uncle had done that way back when?
Well, it was too late. I mean, they couldn't change the articles. The articles were filed, and public record, and
Amend
they had
the
51
articles?
votes, and we had 49 votes.
Yeah.
So there's no changing them.
Can't amend those now. Well, maybe something could have been thought of, or at least come back to the drawing board. But it is certainly an opportunity that we all just sort of put these documents away, let's say, and we never really understand what they say. And when push comes to shove and there's an issue, it's all that woulda, coulda, shoulda. So, it should be part of, let's say, an organization's annual or biannual or whatever it is agenda, where they're having a retreat of some sort and doing something special maybe to pull these out and really go through an exercise as far as what's happening in them.
Well, yeah, and like I said, the thing that when I speak on buy-sell agreements to other lawyers and estate planning professionals, they like the fire drill, because then that gives them something to talk about with their clients that actually results in work down the almost immediately, because that now they make the client they put the torch to the client's seat and heat the chair up a little bit, and they're like, now I'm uncomfortable, and I want you to review my agreement to figure out if there's a problem. And quite often, it also gives lawyers who drafted ambiguous agreements that are out there to clean them up before there's a problem.
Mm-hmm.
Because then they look at it like, what was I thinking when I drafted that? We've all been there. I mean, I've done that. I mean, I'm not too proud to say that I've looked at stuff I did 5 years earlier and say, I don't know, what was I thinking? I didn't think that all the way through. I'm a big believer, Ruth, in the Japanese concept called kaizen, which is continuous improvement.
Yeah.
I believe that everything can be improved, and we should always strive to be better today than we were yesterday, including our draft. That's why the fire drill can be a really effective business development tool for estate planners and for business owners. I don't know who your audience is for your podcast, but if you've got business owners, put yourself through the fire drill, and then give Ruth a call and say, hey, we need to fix this. Because it's important, because while everybody is on the same sheet of music before the triggering event occurs, because remember, before the triggering event occurs, nobody knows who's going to die first. Okay. And of course, I'm sitting here thinking, well, I'm going to survive. Okay. And they're thinking the same thing. They're going to survive. But once that triggering event happens, like I said, the ox is in the ditch.
Right.
The golf cart is off the road and is careened into the ditch.
Right.
And there's no getting it back. The
Right.
toothpaste is out of the tube.
Right.
It's happened. And the party benefiting from it, they're not going to say, "Oh, we'll give you a mulligan." We're gonna redo the agreement. That's never. I've never seen that happen once. People, I'm gonna hold you to the agreement because this was our contract. I'm held to it too.
Right. Right. You talk about, is it the estate planning play, the stage of the
Yes.
estate plan, and all the various players. And by reviewing these documents that were done at some point where maybe an advisor wasn't, let's say, thinking of your best interest, but their best interest, or whatever it may be, maybe it's a chance to rethink what was done in the past, and that estate planning stage with all the players can be reviewed by somebody else with a fresh set of eyes.
That's right.
Yeah. All right. So you make a dramatic point that, a poorly drafted buy-sell agreement can be worse than having no buy-sell agreement. Tell us your thoughts on that.
Well, I wrote that, and I firmly believe it, and I've never wavered from that. Sometimes the agreement can be so onerous or so ambiguous that you'd have been better off, going the corporate dissolution route, forcing a corporate dissolution, or a dissolution of the entity if it's an LLC under state law, an involuntary, dissolution.
Right.
Just break up the business. A lot of times people draft buy-sell agreements to continue them, but if they draft a bad one, it can. And remember that if it's a really bad one and it causes litigation, it's very expensive. I've seen businesses go out of business,
right?
Because the business partners are focusing all their attention on the litigation, quit focusing their attention on the business flounders, and then they're fighting. It's a Pyrrhic victory for the one who wins the lawsuit, that they won, but they didn't. It's kind of like Bobby Bear's old song, "The Winner." When the kid in the barroom challenges the old barroom brawler who's the champion, and he tells him, "Well, son, I've got a cauliflower ear and my knee doesn't work, and so today I'm not going to fight. You're the winner. I was the winner, but I really didn't win." And that's what happens with a really bad buy-sell agreement that ends up staying in effect. And that's why I say that sometimes a really bad buy-sell agreement is worse than not having one at all.
Yeah, and I've attended the first part of your 3-part series on family succession, business planning, and estate planning. And in that, you go into how a good number of family businesses may be better off selling as opposed to.
Well, I can tell you this: one of the most important conversations that a business family needs to have every probably 3 to 5 years is what I call the keep or sell discussion. The discussion that either triggers, a discussion about whether we all want to be in business, what kind of business do we want to have? Maybe we have different ideas. Maybe we need to split the business. Some of the people want to go in this direction, others want to go in that direction, and maybe we can use Section 355 of the Internal Revenue Code if it's a corporation and do a tax-free, split up, split off, that kind of thing. Sometimes brothers, and I'll put the blame on us males, because we usually are the troublemakers, as you know. I'm a firm believer that we need to put women in charge of everything, including my Roman Catholic Church, because the men, all we've done is steered countries and churches into the ditch. But because we took charge because we were stronger physically, we've matured and civilized ourselves to the point where I believe women have an emotional intelligence edge but the bottom line is that the area of, family business harmony requires, and that keeper sell discussion, also could result in, maybe a new idea for a new division, a new idea. But it also can be a renewal of our commitment.
Right.
Maybe they get together and they're on the fence about whether they should stay together, but they meet and they're like, yeah, we got a great business here and we want to stick with it. And now we're going to redouble our efforts. And, Uncle Joe, I remember Uncle Joe on Petticoat Junction, who Kate could never get to do anything. Uncle Joe goes from working 15 hours a week to 30 hours a week because he's now re-engaged in the business. That discussion is a very important one. So I'm glad you're enjoying that. I'm having fun. I'm finalizing the case study for session 3, and it's a Cajun company, and I really reconnected with my Cajun roots. You're gonna love. I work Cajun words in and everything else. It's a lot. It's a lot of fun. It involves a mythical Cajun spice and specialty products company headquartered in Ville Platte, Louisiana, which was about 25 minutes from my hometown, in the heart of the parish seat of Evangeline Parish, Louisiana, in Cajun country. So I'm having fun with that.
Awesome. I look forward to it. Yeah, one of the points that there's so many points, but one of the points from the first part is thinking about how you mentioned people, family businesses may think about the value being in the family business per se, but the value can be in the people themselves, right? Not just the names on the trucks or what have you, but thinking about the value in the people as being very important.
Well, one problem that you run into a lot, and estate planners are notorious for making this mistake, is they tend to conflate the owner's individual estate planning with the business's continuation planning. And, in estate planning, quite frequently, the goal is estate preservation. And the word preservation often gets construed to mean we're going to keep the business. And sometimes some G2s or G3s, generations down the road, they're not as equipped and not as interested in continuing to run the business. They don't have the passion that the founder of the current generation leader has. They don't want to do this. They don't want to live in the little town. They want to move to New Orleans or want to move to New York City or wherever. And they don't want to do this anymore. So the bottom line is that the discussions and that recommitting process is important. But when you put together an estate plan that assumes that the family is going to keep the business, and you don't even explore the possibility of selling, if you have that keep or sell discussion and the family members in the younger generations like, we really don't want this business, we just don't want it. Most of the time, you're going to get more money for the business in a sale if it's sold while the founder's alive, to be able to be a consultant for a couple of years, help them transition the clients or customers or whatever. Because what ends up happening is family's silent because nobody can say I don't want to work here while dad's alive, because it would be viewed. I mean, I've even been in family meetings where somebody has had the guts to say that, and somebody come out and say that's treason. That's treasonous. It's against the family. It's anti-family. So people are like, I'm shutting up. I'm not saying a word. But when the founder dies and the business starts floundering, they're like, I don't want this business. Let's sell it. And they end up getting half of what they would have gotten had they been honest during life. And who they blame? They blame the lawyers. They're like, you didn't you didn't advise my dad well, and you didn't have him talk to us about whether we wanted this business. You just said, they want it. Yeah, it's a valuable business. And quite often, it's because the lawyer's firm is doing other work for the company, and they have a conflict there. They don't want, like, well, if we sell the business, we lose the client. So then the lawyer's, got a personal conflict, business conflict with his client. So, I mean, this happens all the time, and families blame. I mean, when you got a sale for half, there's going to be somebody blamed. There's a fall person, and usually the lawyer.
Mm. Well, I'll just mention two other concepts that I just love, but then I'll move on. I love the differentiation of self and the triangle theory. So,
that's from Bowen. Yeah, that's great stuff.
Yeah, great stuff. All right. So, in your opinion, what's the number one fatal mistake that most lawyers make when drafting buy-sell agreements?
I think the number one mistake that lawyers make is what I call the cut and paste syndrome. They pull their last buy-sell agreement and they just assume, or they use a specimen agreement from an insurance company or whatnot, and they change the names. They just put in the right names without making sure that it fits. I've always said, Ruth, that a lawyer looking for a specimen or an example buy-sell agreement is an accident waiting to happen.
Yeah.
Because eventually they're going to happen to somebody, and they're going to draft something, and that agreement is not going to work under the set of facts because it was drafted, the specimen or the prior client's agreement is drafted for their facts and not for the current client's facts.
Yeah.
And I think that's probably the number one mistake that people make.
Too many variables.
I found in the 90% number that I gave you earlier, usually lawyers are decent at drafting the triggering event. Where the mistakes are made are in the process. And here's a classic one that I see all the time. There's a triggering event occurred, and the value has to be determined. It's a business interest, a minority interest in an LLC, and the value has to be determined by a business appraiser in 30 days. Well, I've been involved in more than 500 business valuation engagements. Good luck getting your client to answer the business appraiser's information document request in 30 days. And so what happens is you start out behind, and then all the succeeding procedures are pushed back or absolutely made ambiguous because you had this unrealistic thing.
Right.
Business valuation on a good day is going to take 90 days. And normally, I don't recommend doing something less than 6 months.
Yeah.
Because, like I said, a lot of times, the drag is the client dragging their feet, getting the information the appraiser needs to get.
Yeah. Yeah. And you talk about costs of getting appraisals and sort of the issues that you can run into when you get one, I get one, and we compare the two.
Well,
better way to do it.
That's a bad valuation method. That's just more lazy drafting.
Well, sticking with valuation, why is using book value such a major mistake in buy-sell agreements?
Well, as you, in my own family's example, okay, book value is an accounting term. In my materials, there is a case out of New Jersey in the buy-sell. I don't know if you've seen one of the buy-sell presentations on Lineberg, but there was a case, and Ron Perlman was involved in it. I think it was called something versus Booth Computers. It was out of New Jersey. And book value, the book value of the estate's interest was $187,000, roughly thereabouts. The fair market value of the estate's interest was $11,500,000. Well, guess what? The New Jersey trial court said, this is your agreement. 187,000 is the number. And the New Jersey Court of Appeal affirmed, and the Supreme Court denied writs. So they got 187,000 when they were taxed for estate tax purposes on 11,500,000.
Yeah.
So that's why book value, you should run, don't walk away from book value.
Oh my gosh. Horrific. As far as specific guidance concerning how interests to be transferred pursuant to the buy-sell agreement are to be valued, what else can you tell us on valuation provisions?
Well, first of all, using a formula is a fool's errand. It can't be done because all formulas can be manipulated. Even if you build in, you got to use the formula and you got to use generally accepted accounting principles with the most important words consistently applied following. A lot of times people think they're covered if they say generally accepted accounting principles, but if they don't say consistently applied, a lot of times in GAAP, as we call it, there's alternative treatments. And you're like, and you always pick the ones that benefit, one side. You're following GAAP, but maybe you flip flop. You want to be consistently applied. In a valuation for a family business, it should always be fair market value as finally determined. A qualified appraiser, you should spell out the qualifications of the appraiser. You should say what the standard of value is, which, for tax purposes, fair market value. But remember, that's not the only standard of value. You've got fair value, which is a pretty common term in corporate cases, shareholder derivative actions, divorce. And fair value, unfortunately, varies quite a bit in definition from state to state. But the essential difference between fair market value and fair value is fair market value recognizes the levels of value. And in other words, it has, discounts for lack of control, discounts for lack of marketability. Fair value, it's one level, and it's a fractional share. It's a 1/3. You get 1/3 of the value, and there are no discounts. Okay. Mm-hmm. Like I said, it varies from state to state a little bit, depending on the law. But you want to specify the standard of value. You want to specify the level of value. A lot of times, when it comes to the taxing authorities, people want the lowest value. But when it comes to their checkbook and what they're going to get from the sale, the sale to the other owners or to the company, they want the highest value. And of course, if it's a non-marketable minority interest, that's the lowest level of value, and that's going to be subjected to the two discounts. In computing valuation, you first take, because the levels go down, and the discount for lack of control comes off first, and then the discount as you descend to the lowest level of value, you've got the discount for lack of marketability. You should specify what the proper level of value is. And these kinds of things are really important in valuation. So avoid formulas, avoid book value like the plague, avoid the three appraiser approach that you mentioned a few minutes ago. And this is another routine thing I see. And what I mean by that is the agreement says you pick an appraiser, I pick an appraiser, those two appraisers pick an appraiser, and then we average. Well, that sounds to me like a business valuation, a business appraiser's annuity act. You just building in work, because those valuations are not cheap. Maybe you may be paying between $5,000 and $15,000 per appraisal. And what I often recommend is you pick the appraiser in advance. A lot of times you let them appraise it so that everybody see what the current value is, because most business owners have no real idea what their business is worth. They think they know, but until, what appraisers are, Ruth, are really two things. Appraisers are excellent question askers and wonderful, good appraisers, wonderful storytellers. Okay. They get to the bottom of what drives the value of your company. A lot of times, many clients make money and they really don't understand why they do. They don't understand what makes their business valuable. They just know it is. So that's a very, very important aspect of this is the appraiser being able to really get to it. And you pick one appraiser and you specify all the things I mentioned. The level of value, the as of date. What's the date of the valuation, the effective date of the valuation? The valuation is never going to be issued on the as of date, because the as of date may be date of death, or it may be the alternate valuation date under Section 2032. But the date of the gift. But there's going to be a date. That's the as of date. The valuation's issued, 6-8 months later. But it's what's the as of date? That should be clear too.
Right. And if we have any estate tax concerns, we are even that much more concerned. And if we have family business succession plans with the discounts, then we have even more concerns with valuation. But all right, I think last question here. How important is it to consider funding buy-sell agreement future purchase obligations, and how purchased interest under the buy-sell agreements will be paid for?
Well, that's a very important question, because sometimes people draft the agreement and they don't say anything about it, and a triggering event occurs. He says, "I want cash on the barrelhead." Well, wait a minute. We don't have the cash. And so now you're scrambling. You say, "Well, we're going to put you in default. We're going to sue you for breach because you didn't pay us." And it said, we're entitled to $1 million. And the agreement doesn't say that you can put it in a note or whatnot. So you need to specify, if how the consideration is paid, when it's to be paid, if there's interest on the note, if the note permits security. And then one other thing that I have found is very useful, particularly in often in family companies, if you've got like a big G2 group, you've got 4 brothers, and they're all fairly close in age. If you're doing redemptions and one of them dies and you're paying them out over time, and before you finish paying out Bertrand, Placide dies, and he's like, we don't have any money to pay Placide's widow because we're paying Bertrand. Okay, and you're like, you should think about that. And I build in the buy-sell agreements a reduction in the first payment to accommodate that second purchase, because the answer sorry is usually not a good one. But that's something that people a lot of times don't think about.
Right. Yeah, that's such an excellent point. Anything else you want to mention before we leave? You're just amazing, and I thank you so much for being here. And
well, I'm just rambling here. I certainly have enjoyed it. I would, if you have other questions, my website is paulhoodservices.com. I've got articles there. I got white papers. There's a specimen buy-sell agreement, what I call the interest transfer agreement. That's all there, and it's all free, and give it all away just because the quality of buy-sell agreements, in my estimation, in this country is really deplorable.
Mm.
And I think that's why 90% of them that I see have significant defects in them. So I'm trying to, do my little part as one little guy to improve things. And so anyway, that's about it, and if I can help you in the future, I mean, please let me know. I've enjoyed being your guest, and if you ever wanted me back, I'd be happy to come.
Absolutely. I would 100% want that. So thank you so much.